This final module, we're going to wrap up on just some of the actual specific laws that protect people in regards to psychological test and measurement. So the 14th Amendment is the first one. So basically, all U.S. citizens are protected equally under the laws of this nation. So does a test restrict rights and opportunities? So basically the 14th Amendment and psychological testing and measurement means that if a test is being used to restrict rights and opportunity, it is under the possibility that it is violating the 14th Amendment. So if a test is found to be, for example, discriminating against a particular group, the 14th Amendment is one of the first laws that's actually providing access for us to say that if every citizen should be protected equally under the laws, if there is a test or a psychological test that in some way might end up restricting rights or opportunities to different groups differentially, then it's violating that federal law. The Civil Rights Act, Equal Employment Opportunity Act, basically, so in the late 60s, early 70s, we had numerous laws, including the Civil Rights Act, which actually created a federal bureau, the EEOC, which is the enforcement arm of the Equal Employment Opportunity Act. And basically what these laws are is even more specifically stating how do we actually quantify whether or not a test, a psychological test, whether it's being used to determine if you get into school, whether it's being used for hiring, whether it's being used to determine a promotion, is actually, basically affecting different groups separately. The Civil Rights Act actually bans subgroup norming. So you can't actually create a test that lets people in with different scores. So, for example, you can't say, well, instead of changing the ACT to be fair to everyone, we'll just let different groups have a different bar they have to pass to get in. That's not allowed legally because, again, it violates the 14th Amendment. We're treating people differently. So it's up to psychological tests, to try to create tests that are actually racially, gender, basically any protected class as culturally neutral or culturally sensitive as possible, to where they're not going to actually differentially treat people. So racially biased testing is the problem that these laws address. And we're going to talk about in the next slide basically the idea of adverse impact. And adverse impact is one of the major marker points or bars that a psychological test and measure must pass to not be in violation of the Equal Employment Opportunity Act, the 14th Amendment, and also the American with Disabilities Act. So the American with Disability Act further says that accommodations are made for those with disabilities. So basically, the American with Disability Act says that, again, when given a test, that if someone has a disability that makes it more difficult for them to pass the test, accommodations must be made. So, for instance, if someone has an actual recognized disability that makes it harder for them to read, they might be qualified to have someone help them read that test or given extra time to take that test. If someone has a vision impairment, they might be allowed to take a different version of that test with larger font, etc. So that, again, the American with Disability Act impacts how we give tests, dependent if someone actually is seen as having a disability. So adverse impact is basically often called the 4/5 rule, and 4/5 means 80%. And what the 4/5 rule states is that basically if there is a selection test, regardless of what it's being used for, so any psychological test that actually is being used for diagnostic purposes, being used for hiring purposes, being used to classify people or to qualify people for various training, getting into colleges, etc., that it is up to the organization using that test to keep track of data on protected groups. And again, the protected groups based on the Civil Rights Act includes gender, religion, ethnicity and race, national origin, and through additional laws, age, and also disability. So what you have to do then is that as an organization using any form of selective test, a test that differentiates people, a test that is being used to make a decision, you have to ask how many people from each protected group is actually taking the test and how many of them are actually passing the test. So, for instance, we're going to look at the very top line here, written test. So under males, 200 people took the test, 130 people passed the test. Now, the way we get that percentage is anytime you need to calculate a percentage, you simply take the smaller number divided by the larger number. So 130 divided by 200 is 0.65. 65% of men passed that written test. Okay? Now, the performance test, the second line, again, just looking at males. 130 took it, 95 passed it. 95 divided by 130 is 0.73. And again, the oral board, 95 took it, 76 passed. So again, 0.8, 80% passed. So in all three of these cases, the percentage of people that pass for males are in that blue bar, 65%, 73%, and 80%. Now, taking a look over at the females who passed. When we look at the females, 125 took the test, only 60 passed, so that's 0.48. So our question now here is that 48% of females passed, 65% of men passed. The way we actually calculate adverse impact is that we actually need to figure out what is the 4/5 or 80% of the highest selected group. So on the written test, that top line, our highest group is males. More males pass the test than females. And again, we're not looking at the number, we're looking at the percentage. 65% of men passed, only 48% of women passed. So the blue bar compared to the golden bar. Now, what we need to know then is what is 80% of the highest selection rate? Highest selection rate in this case is on the written test is men, 0.65. So 0.65 times 0.80. That gives us our actual adverse impact value. So we're going to do this for each of the males, because notice that the males always had a higher selection rate actually in this case, except in one case. So on the written test, 65% of men passed, only 48% of women passed. In the performance test, 73% of men passed, only 53% of women passed. Now, taking a look at those numbers, so with the written test, 0.65 times 0.80, 4/5, 80%, is 0.52. That's that red bar. That's our adverse impact. So the adverse impact value for the written test, the best group that did the best on it, had a 65% pass rate. So any group that passed at lower than 52%, 80% of the dominant group, are basically, that indicates adverse impact. And in this case, only 48% of women passed. That means we have adverse impact. Women are passing the test at a lower rate, lower than 80% of the rate that men are passing that test. Now, when you find adverse impact, it simply means that there is the potential that a civil rights federal law has been violated. Now, the organization that has got this data could then actually try to defend their test and say, yes, more men pass, but actually more men have the skills necessary to do this job, or the skills necessary to get this promotion, or the skills necessary to get this education. But if they can't prove that, then that indicates that that the test is doing differential prediction. It's basically favoring men above women when it shouldn't be, and that violates federal law. Just a few other court cases that have come out against testing. So Griggs versus Duke Power in 1971 is a really big employment law case that involved employment testing. And basically it was using IQ testing or cognitive ability testing and also education for employment. And what happened here is that that by using cognitive ability and what kind of diploma you got, so did you graduate high school, did you graduate college, as markers for employment, Duke Power was finding that they were hiring more white men than any other protected group. The courts actually came out and ruled against Duke Power and said that they couldn't be using these testing and education requirements specifically because it wasn't shown that cognitive ability and education were actually a requirement to do the job. So in other words, the testing was not valid for the employment purposes. If they could have proved you need to have a high cognitive ability and you need a college education to do the job we're hiring for, even if those two qualifications had differentially basically caused adverse impact on a minority group, they would have been legally able to still use those assessments. However, the court in this case found you have to prove that they're actually tied to job performance, and Duke Power failed to do so. Additional cases include Deborah P. versus Turlington, GI Forums versus TAE, and basically this is looking at achievement testing to pass high school. Judges actually ruled in favor of the testing in this case. So this was again a challenge to a nationalized testing, the idea of having to complete kind of a competency test in order to be able to finish high school. So you don't just pass your classes, you also, some organizations, some high schools require you to kind of test pass an overall test. This is also fairly common in graduate schools. A lot of graduate programs have what's called a comprehensive exam. So even if you complete all your classes, if you don't pass that exam, you don't get the degree. The judges in both of these cases ruled in favor of testing. Basically, the testings were valid despite adverse impact for minority. In other words, there was finding that by putting on this achievement test at the end, that certain protected groups were less likely to pass. But also, the organizations, the high schools, showed that these tests are very closely tied to finding out, does the person have the education that their degree indicates that they actually have. So there was found to be instructional validity, that basically these tests were measuring the instruction that was being offered at these high schools. And there was also consequential validity, that in order to make that degree worth something in the hiring market, that these tests gave further assurances to hiring organizations that that high school diploma meant something. So some additional court cases against testing: Larry P. versus Riles in 1984. Judge ruled IQ tests are illegal for African American children tested with mild retardation. So this is again a case where there was adverse impact being, basically African American children were being found to be more likely to be diagnosed with various IQ tests as suffering from mild retardation. The tests themselves were questioned, and it was found that they were not necessarily valid or culturally normed, and therefore the African American children were not necessarily suffering from more mental disability. They were actually not as well familiar with the testing, and therefore were being given lower scores. Pace and Hannon in 1980, judge ruled that IQ tests were not culturally biased against African American children, so this goes in the other direction. And each time, these tests are often different tests in different settings. Thorough evaluation of the test was made, and the tests were not the only determinant in educational placement. So what this one was, in this case, it was found that IQ tests were somewhat related to performance and later in school, but also that in this particular case, they were not the only test being used, the only determinant of whether he got in. But also in 1994, Crawford versus Honing, a judge overturned many previous rulings in IQ tests, making it actually, again, generally speaking, where we're at today as far as cognitive ability testing and possible violations of federal law, including the Civil Rights Act, is that if you're solely using a cognitive ability test to make a determination, and there are no other tests being used in conjunction with that test, if it is also resulting in adverse impact, then generally speaking, it is very hard for an organization to show that that is the best way to test for that job. Cognitive ability is somewhat related to performance in almost all occupations, but it's also often a fairly small determinant. Also, cognitive ability tests have been severely revised over the years to where many of them no longer are showing adverse impact.